Good afternoon. I'm sorry, could you guys unmute? We can't hear for the please. Thank you.
Does need to be arraigned. And so at this point, we are going to rearrange the defendant unless he was not arraigned at certain point.
Judge, I wasn't part of that proceeding when you guys sent
Mr. Cripps, was he rearranged at
He was arraigned originally on the grand jury indictment, but never rearranged after that.
well, he has to be rearranged with these cases, with this the cold cases. We're gonna go through immediate arraignment. And is he already on bond?
Yes,
Okay, what is his bond currently?
may I consult with my client?
Judge, while Mr. Cripps is consulting with his client, I believe the clerk read that the charge with assault with intent to murder and assault with intent to do great bodily harm, less than murder. On the grand jury indictment, Mr. Hill was bound over on those two counts as well as he was bound over on the count of discharge of a firearm in a building and 2 counts of felony firearms.
Can you produce anything to that? We don't have that. That's why. That's why these proceedings are difficult. We had one yesterday where we were proceeding with something where that person had been acquitted at the trial. So,
I can approach the court with the grand jury indictment.
Well, except for we're objecting to the use of the grand jury indictment, because that's improper. I'll renew my objection.
the objection is continuing.
I just need a copy of it. It's on. No, it's on.
Anybody?
Yeah. No, it's on. I got the text message.
Okay, so it's all of these charges?
Yes, ma'am.
Okay. Calling case number 2206020101, people of the state of Michigan versus Kyle Hill. Defendant is being charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Counts 3 and 5, weapons, felony firearm, and count 4, weapons, firearms, discharge in or at a building causing injury.
Appearances again.
Good afternoon again, Your Honor. Orion Day Patterson representing the people.
Good afternoon, Honor. David Cripps, P3497, appearing on behalf of Lyle Hill. He was standing away the reading of the complaint warrant.
At this time, this will serve as an arraignment. Bond will continue. And now we will go directly to the examination.
Thank you, Honor.
Call your first witness.
Yes, Your Honor.
I do. The last one, too.
Why?
You know what? No, wait. You said, Mike, you said your phone here? Hold on. Is this long enough? You raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand.
Have a seat, man. Keep your voice up, please.
Just I do have a preliminary matter in relation to Ms. Hill. At the time of this incident, Ms. Hill and my client Lyle Hill were married. And the defense would assert the marital privilege in relation to her testimony against Mr. Hill. This has been litigated up in circuit court, but I'm reasserting the privilege.
So this issue was litigated in circuit court. The circuit court judge, that being Judge Miller, granted Ms. Hill the right to exercise her spousal privilege right. That issue was taken up with the Court of Appeals. The Court of Appeals issued an opinion. That being people of the state of Michigan versus Lyle Howard Hill. The opinion was decided December 3rd, 2020. It was decided December 3rd, 2020, where Ms. Hill was not allowed to exercise her spousal privilege based on an exception to the rule that was cited in the opinion given by the Court of Appeals. And I did explain that to Ms. Hill, as well as I would imagine that Mr. Cripps does have a copy of the opinion.
What is the exception? I don't have a copy. What is the exception?
The exception is term called the spousal wrong exception. WRONG. Essentially, Judge, it's when ordinarily a spouse can assert a privilege, but when you are asserting that privilege at a time when the crime affects a third party, and the court has ruled that the spouse cannot assert that particular privilege. So to give some context to what I'm talking about, the allegation in this case is that Ms. Hill got into an argument with her.
Maybe we should have the witness question and go with that.
Ma'am, step down.
So, the allegation in this case was that, Ms. Hill and Mr. Hill were given a birthday party for their 3-year-old child. Ms. Hill and Mr. Hill got into an argument at that party. The argument became physical, between those two. Daniel Simmons, who is the brother of Ms. Hill, got between the two of them to keep Mr. Hill away from his sister. Because Daniel Simmons got into the middle of those two, pushing ensued between those two, where at that point, it's alleged that Mr. Hill took a gun out and shot Mr. Simmons in the midsection. The Court of Appeals has said that Ms. Hill can't assert her spousal privilege when incidents like that happen to a third party. And that's written in the opinion that was decided December of 2020. The case was sent back to circuit court for further proceedings, and we were proceeding about to set a trial date for this case. Mr. Chris filed for a motion to dismiss, causing the case to get sent back here. But the issue as to whether Ms. Hill has to testify has already been decided.
Is that correct, Mr. Cripps?
It has, I didn't agree with the opinion. Of course, the Court of Appeals says we thus are left with no authority that definitely answers the pertinent question in the precise procedural context of the case before us. All the other cases that I read had to do with the person who they found the spousal wrong exception applied, where there were criminal charges also brought, whether it be felony or misdemeanors, by the spouse who was asserting the privilege. Here, there were no spouse abuse or assault, battery, no charges brought whatsoever by Ms. Hill against Mr. Hill. So I thought that would say that the case wouldn't fall under the spousal wrong exception. Judge Cox the Court of Appeals disagreed with me. That's why we're back here. But I'm just reasserting.
Understood. Okay, at this point, the Court of Appeals has spoken. Allowed to testify. My understanding, I'm not sure this was decided correctly, however, it was decided, and we will get back in.
Thank you, Adam.
Man, you're still under oath. Allison.
Thank you, Your Honor. Good afternoon, ma'am.
Ma'am, you're gonna have to keep on saying
Would you state your name for the record, please?
Taylor Hill.
And Ms. Hill, do you know a person by the name of Kyle Hill? Pardon me, Lyle Hill.
Yeah.
Lyle Hill, Lyle, is that correct?
Yes.
How do you know Mr. Lyle Hill?
He's my husband.
And how long have the two of you been married?
8 years.
And do you have kids in common?
Yes.
How many kids do you have?
2.
And ma'am, do you see Mr. Lyle Hill here in court today?
Yes.
And can you point for the court to where Lyle Hill is situated and describe what he's wearing?
Maybe. Sure.
Judge, I hate to interrupt, but there's multiple people in the courtroom. I don't know if they're witnesses beyond the OIC or not.
Yeah, Ms. Frosty, who are the people?
I didn't get what the court said.
Who are the people in the court? In the front row, besides the secretary?
The OIC is in the courtroom as well as the Assistant Attorney General from my office.
Thank you.
Okay, thank you. Continue.
Ms. Hill, can you describe again where the person you identified as Lyle Hill is situated?
Right here.
And what is he wearing?
Oh,
Is he standing or sitting? Your Honor, can the record reflect that the witnesses identified the defendant, Mr. Lyle Hill?
The record will reflect identification.
Ms. Hill, let me draw your attention to the date of August 23rd, 2019, where you and Lyle Hill living together on that date?
yes.
And on that date, where were you living?
On Troster Street, 15069.
Troster, is that spelled Troester?
Yes.
And is that an address located in the city of Detroit?
Yes.
And ma'am, who all was living at that address on August 23rd, 2019?
My husband, my children. myself.
All right, and on that date, were you having any type of event?
Yes.
What type of event were you having?
My birthday party.
And the birthday party was for whom?
Our son.
And the age of your son for which the party was being, for which the party was for? At that time,
Yes.
how old was your son?
324.
Okay. And did you in fact have a party?
Yes.
How many people attended the party?
Probably about 8, 9.
Do you remember who all was at the party?
Yes.
Can you tell the court the 8 or 9 people that were there?
My mom, my children, my husband, a couple of like children that are our friends' children, my brother, his child, and
And I apologize if I just asked this, was your husband, Mr. Hill, there at the party? And Ms. Hill, did something happen at the party that caused you to be here today?
yes,
And what started or what caused whatever incident happened at the party? What started that incident?
we had a disagreement, and that's how it started.
Who had a disagreement?
My husband,
What was the disagreement over?
I believe it was the music that was being played at the party.
And who, between you and your husband, who disagreed with whom over the music being played?
It was just, we both disagreed with one another. Okay.
All right, and what did your husband or Mr. Lyle Hill want you to do as it relates to the music?
Objection, Your Honor, is to speculation as to what someone else wanted someone else to do. She can't read his mind.
Well, I'm not asking for the freedom of mind, Judge. I'm asking for the answer as to what Mr. Lyle Hill may have said, which is not hearsay.
That's a different question.
That is different.
Okay, what did Mr. Lyle Hill say to you regarding the music?
I'm really not sure. I think I don't know, we changed the playlist or something.
Well, I object if she doesn't remember and speculating.
Oh, well, Ms. Hill, do you remember what the argument was about?
It was, I know it was the music, it was about the playlist that was playing.
Okay, about the music playlist?
Yes.
Okay. And was this an argument that was occurring in private or out, where people could see, where people were?
I don't know, people were outside, it was kind of like a mix, I don't think we were indoors, so I'm not really sure. If it was probably like two people in there at the time.
Okay. This argument, I believe you just stated it, but you correct me if I'm wrong. Did this occur inside the house or outside the house?
Inside.
Okay. And did this argument ever turn into anything physical?
Between my house.
Yes. Did your husband
I
ever,
didn't hear your answer.
No,
did your husband ever put his hand on you at all?
Yeah, I'm gonna renew my objection to you, Honor. Under the spousal privilege, obviously, she now testified there was nothing physical between them, which changes the whole context of the legal analysis as the spousal privilege exception.
It doesn't change the analysis because Mr. Cripps has already acknowledged that nothing happened that for which Mr. Hill was charged as to doing anything with Ms. Hill. And the Court of Appeals has already ruled that that doesn't change, that she can be compelled to testify.
That's not exactly what they said, Judge. They said because there was a physical confrontation and an alleged poking of my client of his wife, that there didn't necessarily have to be criminal charges, but there still has to be some physical basis for an assault. And now she's testifying that there was no physical assault on my client on her. So I think that undercuts the analysis of the opinion and how it should apply in this case because of that.
Judge, I don't have a copy of the opinion, but I think Mr. Cripps is not reciting what the opinion says. The opinion specifically says, and I'm reading from the opinion, that Taylor was not vested with a spousal privilege because the spousal wrong exception applied. Therefore, her consent to testify was not required, and she could be compelled to testify. By reaching a contrary conclusion, the trial court erred. Now, it's a 6-page opinion where they discuss in the opinion that there are cases where the spouse, the spouse who's trying to allege the exception was some type of assaultive behavior or act was committed against the spouse. There are some cases, Michigan cases, prior cases where nothing happened to the spouse. And the court had to figure out how to determine whether the exception applied or not. In this particular case, it was decided that Ms. Hill was not assaulted. And yet, even given that situation, because someone else was injured, she could not use the spousal privilege. Now, if I'm reciting the case wrong, then maybe we should just print out the 6-page opinion so the court can read for themselves as to what it says.
I can read from the opinion. It says, according to the allegations, defendant made physical contact with Taylor, and Taylor feared for her safety, causing her to ask Simmons for help. So it's based upon the physical contact, and I understand the opinion. I have a copy.
Mr. Cripps is saying based on his understanding, Judge, which is that's a catch-all as to his understanding could be wrong.
Well, I just
The
read it from it.
opinion clearly says that in situations where there is assaultive behavior or there is not assaultive behavior against the spouse, when an individual, a third party is injured, the spouse cannot assert privilege. That's the whole basis of the published opinion, which is why Ms. Hill, it was referred back, was sent back to circuit court, and that she could be ordered to testify.
Continue. Objections overruled.
Ms. Hill, I had just asked you a question as to whether Mr. Lyle Hill had ever put his hands on you on that day at your house. Is that correct? All right. Do you recall, or were you asked back in 2019 to appear before Judge Thomas Jackson for to testify regarding what happened?
I believe so.
All right, and do you recall if you were asked a question at that particular point as to whether Mr. Lyle Hill put his hands on you at any point in time? You don't remember that question? Would reading the document or taking a look at a document maybe refresh your memory as to whether you were asked that question?
Yes.
May I approach the witness?
Yes.
Which page are you directing her to?
Just one moment. Take it, out of order here. Page 27.
Right, second.
Just for the record, Ms. Hill, have I handed you a document?
Yes.
Is it appears to be a transcript? Look at, it's page 27 for the record, right?
Yes.
Is that a yes? Is that a yes, that we're on page 27? Start on page, on line 16, and then just read it, don't read it out loud, and let me know after you're done reading. I heard you say the word okay. Did you finish reading it? Does that refresh your memory as to whether you were asked the question?
Yes.
Ms. Hill, back on August 23rd, 2019, was there any type of physical touching by your husband to you?
No.
Okay. Were you asked that question on a previous occasion?
I didn't see that. Or no, I did not see. I said that I grabbed my brother and asked him to stay with me because it'll get beyond this.
Say that again.
I grabbed my brother and I asked him to stay with me because I know we'll get beyond this. And then he walked.
May I approach the witness again, Your Honor?
Yes.
You see, am I showing you the same page 27? We have to start, let's back up, start at line number 6. You started line number 6?
Yes.
Did you read all the way to the bottom? Okay. Does that refresh your memory as to whether you were asked a question as to whether there was any type of physical touching between you and Mr. Lyle Hill? All right. And when you gave this testimony, were you testifying under oath?
Yes,
And did you swear to tell the truth?
yes,
All right. Did you testify previously that Mr. Lyle Hill touched you?
yes.
And where did he touch you?
Both my face.
He poked your face?
Yes,
And when you say he poked your face, is he poking your face with his finger?
yes.
All right. And when he's poking your face with his finger, do you have a brother?
Yes.
What is your brother's name? Daniel what? Where is Daniel Simmons when Lyle Hill is poking your face with his finger?
At this time, I'm not sure, I don't know if he was like out the house. Because he did leave at a point, so I'm not sure if he was already out the house. So,
Okay, and after, Mr. Lyle Hill is, poking your face with his finger, did Mr. Daniel Simmons try to get between the two of you?
yes,
And when he tried to get between the two of you, are you inside the house or outside? And what happens when Mr. Daniel Simmons tries to get between you and Mr. Lyle Hill, your husband?
and they began to argue.
I couldn't hear.
I said they began to argue.
And what happened after they began to argue?
A fight.
I didn't hear you.
They began to,
And when you say fight, are we talking with fists?
yeah, it's, James, the heat on, I guess, this, I'm not sure.
Objection to speculation, then, Your Honor.
Yes, and Ms. Hill, I'm not looking for you to sustain speculate. Did you see your brother Daniel Simmons throwing punches?
They both, yes,
Okay. And was this in the front room of or in the room inside your house?
yes.
After those punches were thrown, what happened?
They were still, like, my mom left the children.
All right.
Still, my mom left the children.
Okay. So around this time, when this is occurring between you, Daniel Simmons, and Lyle Hill, did your mom gather the children up in the house?
Yes,
Did she take the children outside the house?
yes.
And after your mom took the children outside the house, what happened at that point?
They were fighting and brother ended up getting shot.
Your brother ended up getting shot?
Yes.
Who shot your brother?
Objection, Your Honor, speculation.
Ms. Hill, are you standing there when your brother is shot?
Yeah, well, I really don't remember where exactly I was at, but I was, no, I was still in,
Did your husband, Mr. Lyle Hill, have a gun?
yes,
Was he wearing a gun there at the party?
I'm not sure. I'm not sure.
So let's back up. You've already stated to the court that Mr. Lyle Hill and Daniel Simmons were fighting. Is that correct? Is that a yes?
Yes,
Okay. And then you state at some point, you hear a shot.
She didn't say that, Judge. Judge.
Objection sustained.
Ms. Hill, do you hear a shot?
I did.
And is
What
this
I
a,
assumed to be a shot.
I couldn't hear the last.
I said what I assumed to be a shot.
and
That would be speculation, Judge. Yeah.
what type of noise did you hear, Ms. Hill?
Sound like maybe like table or. I don't know.
Ms. Hill, were you asked a question at the prior testimony before Judge Jackson as to whether anyone produce the gun?
I'm going to object to that, and I should have objected earlier, to use of the investigative subpoena transfer. Because we know that the Supreme Court has ruled it's an inappropriate proceeding. Now, Judge Cox didn't say, I thought it was fine, I don't think that that's appropriate, he just reading it. So as I think about it, I think it's improper to use a transcript for impeachment or refreshing memory or for any use of a procedure that's found to be illegal by the Michigan Supreme Court.
The Michigan Supreme Court found that you can't use a grand jury proceeding to bind a case over the circuit court trial. They never said that the transcript could be used to either impeach and or refresh the memory.
Did they speak to whether it could be used? I mean, because the overall holding of the case was that it was an illegal proceeding and it was unfair to a defendant, and that every defendant is entitled to a preliminary exam. I don't remember anything in reading of that decision that stated that stuff that was stated in the one-man grand jury, which they found to be an improper proceeding, can and will be used against the defendant at a later time.
Well, and I'm not
Yeah,
suggesting.
it just seems like just going back to law school, fruit of a poisonous tree can't bear good fruit. So what would be how would they, unless I missed in the reading of that decision, I don't see anything that states that can't.
Well, Mr. Cripps cited investigative subpoena transcripts. Investigative subpoena transcripts can be used as substantive evidence against the defendant. I'm not suggesting that it be used as substantive. It doesn't change that you can use the transcript to refresh the memory of a witness who swore under oath to tell the truth during that particular proceeding.
But the proceeding was an improper proceeding, right?
Well, it was improper in that it shouldn't be sent directly to circuit court.
So a one-man grand jury can be used in the state of Michigan for some other use?
I believe one-man grand juries can be used because it's no different than coming before a magistrate presenting probable cause. It's just simply a prosecutor that's taking one step further, using the judge to establish probable cause.
The only use of it was to get to straight trial and not go with the preliminary exam. So there would not be a use for a one-man grand jury if you're not trying to bypass the preliminary exam process, right?
Well, in that particular situation, when the court asked me, can you use a one-man grand jury?
Okay, let me, and that, you're correct. You are answering what I asked. So let me ask you a better question.
Yes, sir.
Okay. The process that we have right here, this one-man grand jury and what was in front of Judge Jackson, you're saying that even though it was an improper proceeding, as to establishing probable cause to go straight to trial, you're saying even though it was an improper proceeding, you believe what was taken from it, what was stated in an improper proceeding can now be used to refresh a witness and be used in a court. Is that what you're saying?
I'm saying, yes, it could be used to refresh the memory of a witness who's saying, I don't recall being asked that question, or I don't recall the answer that I
Well,
gave.
what difference does it make whether she recalls being asked a question where she shouldn't have been asked a question in the first place? There never should have been a one-man grand jury in this case. So if she's asked a question that she shouldn't have been asked a question, her being refreshed about something that shouldn't have occurred, what is the probative value?
But the probable value is that she swore to tell the truth, and so she gave answers under oath for a different judge, and so therefore the probable value is that the day of the incident, she swore under oath, she gave an oath to tell the truth, and she gave answers about an event that happened just hours before she testified.
Right. The objection is sustained, and part of previously reporter that was used to refresh the recollection of the witness based on the one-man grand jury is stricken from the record. And going forward, it is not going to be permissible to refer to anything that happened in the one-man grand jury, period. So continue,
Thank you.
Ms. Hill, was your brother shot?
Yes.
Where was he shot?
Again, I have to object to it unless she actually saw it. No foundation.
Did you did you talk to your brother after whatever shot occurred? Yes.
She said it could have been a cable break, so there is, I would object to the characterization of shot.
Objections over.
Ms. Hill, did you go to the hospital?
That night I did, but I wasn't able to go. To see. I went out to see.
And your brother went to the hospital for what?
Objection, she can't testify as to why someone else did what they did. Especially because he went separately.
Okay, okay. Ms. Hill, after whatever happened in the house, did your brother blurt out something happened to him?
That night,
There at the house?
no, he immediately ran out and got into the car. Running back that night.
And when your brother ran out, who all was in this area when all of this happened? When your brother ran out, where did you go? What did you do? Why are you calling the police?
I didn't know it personally.
Did the police respond?
Yes.
And what happened when the police responded?
No, they arrived and they, no one asked me anything. And they, my brother was already gone. No one talked to me. And I think they gave me like their contact information. And
What, if anything, happened to your husband?
he was arrested.
He was what? Ma'am, did you stated that, the Detroit Police Department, did they interview you as well?
That night, I don't believe they interviewed me that night. They gave me their phone number or whoever I was speaking with at the moment. They gave me their phone. And I don't ever remember anyone saying anything to me. They may have asked like what was happening here, but no one hardly knew exactly who I was in the situation. They just gave everyone in the area like that was there at the moment, the contact number.
Well, did the police interview you later on? Maybe not that night, but the next day?
The next day is,
And did you give a statement to the Detroit Police Department the next day?
yes,
And were you asked a question by the Detroit Police Department, did you see your husband shoot your brother?
You have to say yes or no.
yes,
And do you recall the answer that you gave to the Detroit Police Department when they're talking to you?
not exactly,
We're reading the document, refresh your memory.
yes.
Now, approach your
Approach.
First, for the record, ma'am, do I have in my hand what appears to be a 3-page witness statement?
Yes.
All right, take a look at page number 2. And I want you to read kind of where I'm pointing, and just look up when you're done reading. Get you have a chance to read the answer?
Yes.
Does that refresh your memory as to the question that you were asked? Did the Detroit Police Department ask you, did your husband shoot your brother?
Yes.
And what answer did you give?
Yes.
And was that the truth when you were talking to the police?
Yes.
And is that the truth because that's what you saw?
No, it's the truth because I remember hearing my husband call the police himself at the time of the time him explain what happened.
And did you hear your husband explain that he shot your brother?
Just as a leading, Your Honor.
Jackson.
Yes.
And that's what you heard your brother tell the police? I mean, that's what you heard your husband tell the police?
Yes.
Now, at the time, that all this is occurring, did you see your brother with any type of weapon in his hand? So you're saying you don't recall or you don't?
I'm just not, I don't know, I don't think I've seen him.
When your husband is talking to the police and he says that he shot your brother, was that the day that all of this, was this the same day that the party happened?
Yes.
I don't have any additional questions.
Cross. Thank you. Good afternoon, ma'am. You're Taylor Sinclair Hill, is that correct?
Yeah.
And back on the date when this occurred in August 2019, you were legally married to your husband?
Yes.
And as I understand your testimony here, there was a birthday party in progress? And there were some adults there, is that right?
Yes.
Okay. And was there alcohol being consumed at the party?
No.
So no alcohol involved at all? So you weren't drinking alcohol?
I don't think so, no.
Think back, I know it's been a while.
I would know if I was, no.
Were you smoking any marijuana?
I don't think.
And you said that this was an indoor party, is that correct?
So, indoor and.
Okay. And you began playing music at the party, is that correct?
Yeah.
And food was being served to family members at that time?
Yes.
And you said there came a point in time that your husband became upset for the type of music that was being played?
Yes.
The same song was being played over and over again?
Yes.
Okay, so he began to talk to you about that, is that right?
Yes.
Okay. And you got into, were exchanging words back and forth?
Yes.
And would you say that your husband was becoming angry?
Yes.
And the two of you started arguing back and forth, is that correct?
Yeah.
And at some point in time, your brother got involved, is that right?
Yes.
And how did your brother get involved when you and your husband were arguing?
It just like spurred a moment. I asked my brother to stay with me while I, gather my things, and it just unraveled for me.
All right. What did your brother do exactly? Did he come over to where you and your husband were?
Mm,
I'm sorry.
I don't know. I don't believe he did. I think he was leaving out.
I'm assuming.
I went, we like navigated over to our front door.
Okay. So when you say he left out, you mean, are you referring to your brother?
Yeah,
So your brother left from inside the house? Or the room that you were in?
no, we were all in the front room, but I don't know if he left, cause I don't think he left, cause I think he was just like waiting by the front door, leaving our, he was just by the front.
So was he near you and Mr. Hill or not when the argument got?
Yeah.
Oh, all right, so he was near you then, is that right? Okay. And if I heard you correctly earlier, you said that your brother, Mr. Simmons, has a firearm?
No, I'm not sure.
Oh, yeah, sure. It did come a point in time where, when you and your husband are talking, did you ever see a fight occur between your brother and your husband?
Yes,
And that's when your brother came over and got between the two of you? Or explain how you saw those two, where they were when they were fighting?
why they were fighting,
No, where
they were still in the front room by the door.
they were. Okay. And what did you see your brother do in relation to your husband?
They were both, it was just a physical fight.
What did you see your brother?
What did I see him do?
Yeah.
A normal, a fight, a fist fight. I really can't, really, it was a lot going on. I really can't pinpoint exactly what.
You said,
did.
you said a fist fight.
Yes,
So you saw your brother throwing punches at your husband? That yes or no?
yes, okay,
And did you see some of those punches hit your husband?
yes,
Okay. And then did you see them go into the corner of the living room?
yes,
Right. Now, you very clearly have told the judge earlier that you didn't see a shooting, is that right?
no, I didn't see it.
No matter what you've said to the police in the past, no matter what you've signed, is it your sworn testimony say that you did not see a shooting?
No, I didn't.
And in fact, when you heard a noise, you told the judge here that you thought it may have been a table break.
Yeah, I can't remember exactly what I said, but it was something that.
I'm asking what you-
normal. Yes,
I'm asking what your memory now is.
oh, yes,
If the noise that you heard could have been a table break, is
yes,
that what you told us earlier?
Yeah.
And is that the truth?
yes,
And the truth is, you didn't see your husband shoot your brother, is that correct?
correct.
Now, at some point in time, you claimed that you heard some phone call, is that right?
Yes,
Was that the next day or the same day?
no, it was the same day, the same time.
And where were you when this phone call was being made by your husband? Were you in the same room or different?
Same room, we were in the same room, I believe, we got called at the same time.
I'm sorry.
We were, no, he was like in the front still, and I was in the back, and we called at the same. I was hearing him call as I was making the call as well.
Okay, so when you're making a phone call,
Yes,
all right, and at the same time that he's making a phone call,
yes,
you're in one side of the house
yes,
and he's in the opposite side.
yes,
So you have not only the problem of being a distance away, but you're also talking at the same time.
yes.
Now, could it be while you're talking on the phone that you may have not heard correctly what you think you may have heard as you sit here today?
Possibly, yes,
Okay. And could it be that you heard your husband say that somebody had been shot as opposed to saying that he shot someone?
possibly, yes.
Go ahead, you sit here today, I mean, this is the last time I have. You can't say on this record, based on your memory, that you ever saw your husband shoot your brother, is that correct? And you can't say for sure that you even heard your husband say that he shot your brother, isn't that correct? Nothing. Redirect.
Ms. Hill, I just want to, just, as we talked about on direct exam, again, you gave a witness statement to the Detroit Police Department the day after this incident, correct?
Correct.
And you were looking to tell them the truth as to what happened, is that correct?
Correct.
And you were also given the opportunity to make any corrections to the statement and write in what should be accurately put on the statement, is that correct?
Yeah, well, I wrote it out. Yes, I wrote it.
I mean, I don't want you to guess, I mean, if you want to take a look at it,
Yeah. Oh, I know I wrote it out.
The statement that we're referring to is a type statement that's been shown.
but isn't it a type statement where you cross out a type line and handwrite what you think should be there?
Okay, yes. That's what you just showed me.
I just showed it to you, but I can show it to you again.
Sorry. Yeah.
Okay. And so not only did you, is there a statement, but then you had a chance to read the statement and then make corrections to the statement if you so chose. Is that correct?
Are you able to see me?
Well, can I just approach the witness, Judge? And just show her that she seems to be confused about whether she made corrections or not.
I think she's confused. She said she did. Did you make corrections to that type written statement, to that type statement?
I wrote it myself. I wrote the statement myself.
Yeah.
Yes, Your Honor. See, I'm showing you this is a DPD interview statement. Is that correct? All right, now you see how on the document, it's a typed statement, but sometimes there's a line through the statement where there's handwriting. Is that your handwriting? Would there be corrections on page? So what you looked at so far is that there's a paragraph and there's a line through one of the sentences of the paragraph where you make a correction. Is that correct? That's on page 1. Is that correct? Going to page 2, are there also corrections that you made to page 2? Is that? Ms. Gill, would you agree that your memory was a lot better back in 2019 than it is today?
Yes.
And would you agree that you were looking to tell the truth exactly as to what happened at your house there on Troster Street? Do you remember being asked a question? Or do you remember giving the answer while they were tussling? We all heard a pop and then it got quiet.
Yes.
Do you remember giving the answer? I stepped back and then my brother was holding his side.
Can I ask what the reason for this reading it, a hearsay document is?
I'm asking her, does she remember giving that statement?
What's the relevance of reading the content of the statement to a matter that hasn't been disputed?
So back on August of 2019, ma'am, did you tell the police while they were tussling, we all heard a pop and then it got quiet?
Yes.
Did you tell the police, I stepped back and then my brother was holding his side?
Yes.
Did you tell the police that your brother then said this nigga shot you?
Objection, Your Honor, using this hearsay document to bring on warriors.
No, each question I asked Judge, I'm asking her, did she tell the police back in August of 2019?
Okay, this is redirect, Mr. Prosecutor. Is there some, it seems like you're going into new ground testimony. Are you refuting something that, what are you refreshing her recollection of?
In the cross-examination, Judge, Mr. Cripps, through his questions, Ms. Hill has stated that she doesn't know what happened. She didn't see what happened. Everything could be essentially wrong. And what I'm pointing out is that that's not what she told the police. I'm asking her, first of all, did you tell the police that this did happen? Because this is redirect based on what happened on cross-examination. Is that what she told the police happened just hours after the shoot?
Except when you do it this way.
Yeah, I mean, she's not, I mean, but you're asking questions from a statement as if she said she didn't say that, and then you're refreshing her recollection of the statement. She hasn't, I mean, we haven't gone into the statement before, so you're impeaching her with her statement as if she's denied what she's already stated. She hasn't been asked about that statement. And now you're impeaching her with the statement as if she has denied what that question is that you're trying to elicit.
Well, I did ask her about this statement on direct. I did ask her about the statement. This is where the question exactly that I asked, amongst other questions, did you see your husband shoot your brother? She gave the answer yes. That was asked on direct from this particular statement. Ma'am, were you asking a question? Or did your husband say anything to you after this incident as he was being taken away by the Detroit Police Department?
Objection, Your Honor, to misstating the question.
Are you reading from a previous question or are you asking your own question?
I'll read from the previous question.
There's nothing in there about after assumption that it's taken away from the state.
No, there's nothing in front.
I'll rephrase the question, Judge.
I mean, if you're I mean, it's not to rephrase. I mean, if you're asking a question from a question, either just read the question and ask it, but this is what I'm saying. It seems like you're impeaching from the document that she hasn't denied nor confirmed. That's why I'm confused at what you're doing. So you're impeaching your own witness right now, or is this what we're doing, or I'm confused at what's happening.
It clearly would be.
Would you like to let the witness read her statement to refresh her recollection and then ask the questions? Because it seems like you're just going to ask each question that was asked in the interrogation. I've never seen that done before. If the person is not saying they don't recall, I don't understand what you're doing right. So, and we're not gonna sit here and go line by line when she's not denying it, because you either approach her with the statement and let her see it, and then if she's going off, then you can go ahead and impeach her, but you're literally impeaching with your witness when your witness has not been asked those questions today and denied. That's true.
Ms. Hill, did your husband say anything to you after the shooting?
No,
Did you tell the police that he said something to you after the shooting?
no. I didn't see him after the show.
Now, I'm supposed to witness with the statement.
Yes.
record, Ms. Hill, are we looking at the three-page statement? Have you looked at that particular question toward the bottom of the second page?
Yes.
Did you read the question?
Yes.
Did you read the answer?
Yes.
Does it refresh your memory?
Yes.
Did your husband say anything to you after the shooting?
Yes.
What did he say?
This is what you're waiting for.
This said, this is what?
This is what you're waiting for.
Where were the two of you when that was stated?
Maybe outside, maybe inside, still or outside.
Nothing else here.
Okay, ma'am, I just a little bit of follow-up, okay, then I'll be done. Now, you said you saw your brother holding his side, is that right?
Yes.
But did you also tell the police you saw your brother hit his elbow on a window?
Yeah, our window was broken.
And you saw your brother hit his elbow on the window, is that correct?
Yes.
Okay, so he may have been holding his arm because
Well,
he hit his elbow on the window?
Objection. This goes beyond any questions that anybody has asked previously. I think the rules require that Mr. Cripps only go into what I just went into just now on record.
But that's what he was doing on redirect a little bit about trying to suggest that he was hurt from a shot, when in fact, he hit his elbow on it.
Well, that's an argument. It's not an objection.
Objection to that.
Okay. Now, you've said under oath at least twice that you didn't see your husband shoot your brother, is that correct?
Correct.
And then, Mr. Patterson stood up and showed you a typed statement, is that correct?
Yes.
But you didn't type it, did you?
No.
All right, so a police officer typed it, is that right?
Yes.
Okay, and you, even after looking at the statement, it's still your testimony, you didn't see your husband shoot your brother, is that correct?
Correct.
And in fact, you originally gave an answer that you didn't see him shoot in that statement, is that correct? Thank you, nothing further.
Now you may step down.
Next witness, Judge.
Yes. Sometimes you got to get it off the chest. Yeah, you gotta get it off the chest. You don't get it out. Stuff starts to bubble on the inside.
Judge, for some reason, Mr. Daniel Simmons, who was, oh, I'm sorry, I didn't know. I'm
Okay,
sorry.
let me just get some.
Tell me what I think. Mr. Prosecutor, next witness.
Judge, Mr. Daniel Simmons, who was served with a subpoena to be here and was in fact in the hallway prior to us getting started, is no longer in the hallway, and I'm not sure of his whereabouts. He knew why we were here today, he knew he was being called, he was served with a subpoena to be here, he was in fact here in the hallway.
No.
I'm asking for an adjournment to get Mr. Daniel Simmons here. Or at least attempt to serve him again to be here.
So the defense would object to any adjournment.
Excuse me.
The defense would object to any adjournment.
My finger back trying to keep her. Get out.
Councilman.
This way.
I'm sorry.
Well, what do you gentlemen outside?
Just, okay, you guys go back, you guys go back. Get all the officers in, all the court officers. Everybody. You can go back, you can go back. Come on up. You can go back. Well, back on the record, let your last witness, charge
It wasn't been the last witness, Judge, and just, if I can just state to the court, I spoke to Mr. Daniel Simmons in the hallway. In fact, we gave him a copy of his witness statement to read while he was waiting to testify. I also had him sitting in the witness room with his sister, where he was, I guess, going to stay until he was called. He called Miss Hill first. He went in the hallway to get him, and he's not out.
Well, let's, what we'll do is, we'll give him another minute or so you guys can go out. Is the officer in charge still here? Yeah, have him look for his witness, and you guys go on the hunt, and then we'll come back.
Yes, Your Honor.
Yes, Your Honor.